Madam Clerk, please reconvene us.
Oh yes, oh yes, oh yes. The Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
The court calls 324A19-1 State versus Hollars. Mr. Broad.
Good afternoon, Madam Chief Justice, and may it please the court. Nick Broad, I'm Assistant Solicitor General appearing for the state. I'd like to reserve 5 minutes for rebuttal.
You may.
The Due Process Clause requires a trial judge to hold a hearing on a defendant's competency when substantial evidence raises a bona fide doubt about whether the defendant can understand the nature of the proceedings and reasonably assist his lawyer. The decision below should be reversed because the Court of Appeals failed to make the critical distinction between some evidence that permits speculation about a defendant's competency and substantial evidence that raises a bona fide doubt about a defendant's competency. Substantial evidence must come from actual record evidence available to the trial court at the time it should have allegedly held a competency hearing. Evidence of that kind must be sufficient to raise a genuine doubt in the mind of a reasonable trial judge about whether the defendant is competent to proceed. Under the decision below, however, the substantial evidence standard is really no meaningful standard at all. The Court of Appeals misapplied that standard in two key ways. First, the Court of Appeals took an unduly broad view of what constitutes substantial evidence by looking exclusively at past evidence in the record tending to show that Mr. Hollars was incompetent, while failing to account for more recent evidence in the record showing that Mr. Hollars' mental health symptoms had improved with treatment. Second, the Court of Appeals also took an unduly broad view of what constitutes substantial evidence by holding that a single ambiguous statement by Mr. Hollars' lawyer was enough to require a competency hearing, even though Mr. Hollars' lawyer never asked for such a hearing. Setting the substantial evidence standard so low will have negative repercussions beyond this case. If all it takes to raise a bona fide doubt about a defendant's competency is a single comment or a prior history of mental illness, trial judges will have no choice but to hold ongoing competency hearings over the course of many criminal trials.
Quantify as best you can for us what the standard would be for a trial court to conduct such a hearing sua sponte in terms of what is substantial evidence.
Your Honor, substantial evidence is less than a preponderance of the evidence, but substantial evidence is more than some evidence.
That sounds like law school. What about in this case?
Right. So in this case, there was not substantial evidence in the record before the trial court, either before or during the trial. And let me start with the pretrial record. Immediately before the trial, the court had before it the two most recent competency reports on the defendant's mental health. And those reports both stated that the defendant's mental health conditions had stabilized and were likely to remain stable for the foreseeable future and during the trial. Those are the last two reports in the record from December 2016 and August 2017. The second thing that the trial court had before it, immediately before the trial started, was the September 2017 pretrial competency hearing, at which everyone in this case, all three psychiatrists who have examined Mr. Hollars, the defense attorney, the prosecutor, and the trial judge, were in unanimous agreement that Mr. Hollars was competent to proceed. Under this court's decision in State against Young, that unanimity triggered a presumption that the court did not need to hold a second competency hearing unless substantial evidence raised a bona fide doubt about the defendant's competency in between the time from the September 2017 pretrial hearing and the start of the trial in January 2018. I think the
Is
third
substantial evidence going to be determined on a case-by-case basis? And again, to the quantification aspect of this, how does a trial court determine what would be substantial evidence in light of what those circumstances might be in a particular case?
Your Honor, I do think that it is a case-by-case inquiry. I think the trial court can look at certain categories of evidence in the record to decide whether substantial evidence exists. You can look at these categories of evidence are spelled out in the Supreme Court's decision in Drope. The type of evidence that might be relevant, for example, includes reports on a defendant's mental health condition from psychiatrists and doctors. It would include statements by the defense attorney, the person who's in the best position to evaluate the defendant's mental health condition. It could include statements by the trial judge who's able to observe the defendant in real time, observe his demeanor, for example. And it can also include evidence in the record of the defendant's past irrational behavior. That's not an exhaustive list, but I think in the mine run of cases, those 4 buckets of evidence are going to be what a trial judge looks to decide whether there's substantial evidence in the record. I think there's also a kind of a methodological component to this as well. So I think substantial evidence really is kind of a mode of analysis. It's a mode of looking at the 4 buckets of evidence that I just spelled out. And I think that mode is the trial judge has to look at the record as a whole. I think whole record review means the trial judge has to look at both the evidence that the defendant is competent and evidence tending to show that the defendant is incompetent, and assess the entire record to make a determination about whether the evidence rises to the level of substantial evidence. So just to summarize, I think there's sort of a way of looking at 4 sort of key buckets of evidence, and that methodology is sort of whole record review, looking at sort of both sides of the issue, the evidence showing that the defendant is competent and the evidence showing that the defendant is incompetent. And then I think it just comes down to a question of judging. And I think that these are very fact-intensive cases.
So is this
going to depend on facts.
Is this an I know it when I see it inquiry then?
Your Honor, I'm not sure I would go quite that far, but I do think there is an I know it when I see it quality to the cases and the analysis in this area. As I said, I don't think you're totally at sea here. I think there are some anchors you can drop. And I think Drope is probably the best place to look for thinking about the kind of evidence that is relevant to the substantial evidence inquiry. I think another case that I might commend to the court in particular for this is this court's decision in State against Badgett, which, as far as I'm aware, is the most recent decision from this court on the procedural due process issues at play in this case. And in Badgett, the court specifically talks about this idea of sort of weighing or assessing the evidence both that the defendant is competent and that the defendant is incompetent, and trying to come to a reasoned judgment about whether the evidence is sufficient to raise a bona fide doubt on the defendant's competency.
Do you have to make this inquiry in essence on a moment-by-moment basis?
Yes, Your Honor. I think this is a case-by-case inquiry. I don't think that there are an awful lot of bright lines that can be drawn in this area.
One of the things we've got here is events that happened in the late afternoon, recess, come back in the morning, we have some further events. Hypothetically, let's assume that Mr. Hollars was in fact incompetent at 5 minutes till 5 on the afternoon in which the defendant's trial counsel made the statement that he made, but regained his competence overnight, so that he was incompetent for some period of the trial but wasn't the next morning. Where does that leave us?
Your Honor, if you were to conclude that Mr. Hollars was in fact incompetent for any portion of the trial, that would be a due process violation.
Right. And so one of the things I've been wrestling with here is the trial court's decision to essentially not conduct a late afternoon inquiry when the defendant's condition was fresh in the minds of everybody and waiting until the following morning, because that, changes the quantity, changes the quantum of evidence that's available for looking at the time when the defendant's trial counsel made the statement that's reflected in the record. Are we supposed to look at this as to what was available as of 5 minutes to 5 on the afternoon before, or do we take what situation is the following morning into account as well?
Your Honor, I think you can look at what happens the following morning in this sense. I think what happens the following morning supports the overall procedural reasonableness of what the trial judge did. I mean, the trial judge promised everyone.
Let me interrupt you right there, because the question's not whether the trial court engaged in an overall reasonable course of conduct. I think the question is, as of the time, was there reason to question the defendant's competence at 5 to 5 on the afternoon before, right?
Your Honor, that's right. And let me limit my answer then to just what happened that afternoon. I think what the trial judge did here was eminently reasonable given the full context of what was going on in the trial. And let me give you a few reasons for that. I think a big factor here is that the jury had already been dismissed for the day when this concern was raised by Mr. Hollars' counsel. So there was no more testimony taking place. No one was testifying. Mr. Hollars was not required, as he might have otherwise been, to kind of constantly be consulting with his attorney as an individual testifies against him. The jury had gone for the day. The parties had discussed a very technical area of the law, Rule 404B, and everyone the reporter had gone off the record, in fact. And we come back on the record after, sort of everyone's gone and ready to go home. And this concern is raised, and the trial judge says, in effect, let's everyone just take a beat given where we are at this stage in the trial. It will allow Mr. Hollars and his attorney to consult overnight, and we can revisit the issue in the morning and take stock of things then. And the judge was true to his word. The judge revisited the issue in the following morning, and Mr. Hollars' lawyer said that he did not have any concerns about his client's competency at that time.
Well, what does that say about what his competence was the preceding afternoon? The way I read the record is the way you just said it. I don't have any questions about it as of right now.
Your Honor, I agree that the question is, what was the state of the record before the trial court that afternoon? I agree that that's the key question here. Let me give you a couple of other facts that I think support what the trial judge did and show that what happened that afternoon was not enough to raise substantial evidence of a bona fide doubt about Mr. Hollars' competency. This is really a fleeting moment of the entire trial. So Mr. Hollars' lawyer raises this concern about his client's competency based on a 1-minute exchange between the two of them. But by my count, this trial was roughly about 480 minutes long. That's less than 0.5% of the total trial time, which I don't think is enough for substantial evidence. And I think the broader view here, the broader frame is you have to look at this exchange in light of what, in my view, is kind of the critical moment in this record. The critical moment in this record is that September 2017 pretrial hearing at which everyone is unanimous that Mr. Hollars is competent to proceed. And under this court's decision in State against Young, once you have that unanimity, once that unanimity has been achieved, a court can presume, consistent with due process, that another hearing on the defendant's competency is not required. So the question is really, did anything happen in the interim between this September 2017 pretrial hearing and the trial that would have rebutted or overcome the presumption under Young? And given how small of a moment this was, how fleeting of a moment this was, I just don't think this is enough for substantial evidence.
I'm not sure I'm following your argument exactly, so please help me make sure I'm not misunderstanding you. Are you suggesting that if the defendant is only incompetent for 30 seconds, we can engage in some kind of a de minimis inquiry?
No, Your Honor, I'm not suggesting that.
I'm hearing, echoes of that kind of logic there, and I want to make sure I'm not misunderstanding.
Your Honor, I think if there were evidence in the record that the defendant was in fact incompetent at any point of the proceeding, that would be a due process violation. I don't think that's the case here. I think if you look at what the defense attorney is telling the trial court coming out of this very brief exchange with his client, I don't think the defense attorney is telling the trial court, my client is incompetent, my client, can't reasonably interact with me, my client can't understand the nature of the proceedings. I think what the defense attorney is saying coming out of that, again, very brief exchange is something a little bit more modest and a little bit more ambiguous, which is, and I'm paraphrasing here, but I'm a little nervous about this, right? I'm trying to be a diligent lawyer. I'm trying to bring this to the attention of the court. And I don't think that rises to the level of, the kind of statement that might suggest or might show that the defendant was, in fact, substantively incompetent at the end of the trial.
Let's employ your case-by-case analysis then, as you suggest that we should. You say that there was unanimity of thought that the defendant was competent September 2017 when the trial began. Dr. Bartholomew had given his evaluation 4 months prior to that and has said, among other things, and this is in the majority's opinion of the Court of Appeals, quote, defendant's competency to stand trial is not necessarily static, but can change over even brief periods of time, unquote. Is it your position then that in light of the evaluating physician's position, that although there may have been unanimity of thought that a 4-month evaluation may have stood the test of time, that still there should not have been a sua sponte competency hearing to make sure that over that period of time that competency still remained?
Your Honor, yes, I don't think there was a need based on this record to hold another hearing immediately before the trial, even though there was as you mentioned, a 4-month gap between the final pretrial competency hearing and the trial. And the reason for that is, if you look at Dr. Bartholomew's final report in the record, and this is from August 2017, that report, in my view, states pretty unequivocally that Mr. Hollars is competent, that his competency is stable, and that his competency is likely to remain stable for the foreseeable future. And Dr. Bartholomew said that not only in the August 2017 report, but also in a report 6 months prior in December 2016. So the two most recent reports that are before the trial court on the defendant's competency, I think are pretty unequivocal that Mr. Hollars' competency has stabilized through appropriate mental health treatment and care. I think it would be a very different case if there were evidence in the record that Mr. Hollars' competency was, sort of rapidly fluctuating before the trial.
It had fluctuated over the previous 5 years, of course, back and forth. Should the trial court then have just seen Dr. Bartholomew's statement about the brief periods of time aspect of potential disintegration and just ignored that? Or was there some other way to couch that?
Your Honor, I don't think that testimony should have been flat out ignored. I think it maybe goes to the question of the trial judge's conduct during the trial rather than immediately before the trial. I don't think that there was evidence in the record. I don't think the most recent evidence before the trial court here showed that Mr. Hollars' competency was fluctuating. If you look at the very early reports in this case, there's no question that Mr. Hollars was not competent. He could not have been tried consistent with due process shortly after his arrest in 2012. I think if you look at the full sweep of the record, the full sweep of the record shows that his competency improved with appropriate treatment over that 5.5-year period. Now, I concede, as Your Honor has noted, that there is some testimony in this record, including from Dr. Bartholomew, that Mr. Hollars' competency had a kind of precariousness to it. There's this concern in the 2015 pretrial competency hearing, for example, that the stress of trial might have caused Mr. Hollars to lose his competency. I concede that that's there, and I think it's something that the trial court needed to think about when it was holding the trial proceedings in this case. I think the trial court did think about it and took that risk into account in two primary ways. First, if you look at page 90 of the record, the trial judge entered an order requiring the defendant to stay overnight at the inpatient psychiatric facility where he was housed, rather than at a local jail. The staying overnight at a local jail had caused Mr. Hollars to have a sudden change in his competency in the past, and so the trial judge implemented, I think, a reasonable and adequate pretrial procedure to make sure that that didn't happen again. So I think that's one key way in which the trial court tried to head off any problems with Mr. Hollars' competency sort of rapidly deteriorating during the trial. I think the second main way that the trial court took those precautions is the conduct of the trial court at the end of the first day of trial, when this concern is raised about Mr. Hollars' competency. As I was discussing with Justice Ervin earlier, I think the trial judge made a reasonable procedural decision at the end of the day, with the jury gone, to say, in essence, let's everyone take a beat and reconvene the following morning. And the judge, true to his word, allowed Mr. Hollars' defense attorney to raise any concerns about his client's competency. And Mr. Hollars' lawyer did not have any concerns the following morning. So I don't think the record in this case really fits with this idea of a fluctuating competency. I think that's a different set of cases. I mean, the McRae case, for example, which got a lot of attention in the decision below and has been briefed before you here, is a good example, I think, of a defendant whose competency really has this kind of roller coaster quality to it, and a case in which a trial judge may, in fact, not be able to wait 4 months between a pretrial hearing and the trial, consistent with due process, to evaluate.
Sorry, I didn't mean to cut you off, but along these lines, while you are talking about this issue of fluctuating competency and the evidence that the trial court had before it, what significance do you think we should draw to the fact that the next morning, the other thing that the defense attorney says, which is a little different, seems to me, than what he said the night before or the evening before, was that I just had some yesterday evening, because he kind of looked at me and the look in his face was like he had no idea who I was, which seems a little stronger than he didn't understand the complex 404B discussion we were having, but actually he didn't know who I was.
Your Honor, I concede that that's stronger evidence. I don't think that it's substantial evidence. I don't think it's substantial evidence in light of the whole record, and particularly in light of this idea that this whole exchange is happening after the jury has gone and is coming out of a 1-minute discussion between Mr. Hollars and his attorney. And that, Your Honor, I think may be kind of the nub of the case, is whether you think this, mid-trial exchange between Mr. Hollars and his lawyer and the judge was sufficient to raise substantial evidence rather than some evidence. My argument is that it is not sufficient to raise substantial evidence, because it really is a fleeting moment in the whole context of this trial. And I think it's also helpful to just zoom out a little bit and consider the broader ramifications of a holding that, a statement of kind of this length and ambiguity would be sufficient to raise substantial evidence. I think that this area of the law is very unique because there are no issue preservation rules, right? We're not here on waiver or prejudice. We're not here thinking about invited error or other things like that. And I concede that those rules don't apply, but we ordinarily rely on those rules to incentivize parties to speak up at trial rather than saving an objection for appeal. And the fact that those rules aren't in place, the sort of safety valves aren't in place here, I think is reason to make sure that the substantial evidence standard is not set too low. And with that, Madam Chief Justice, if I could reserve the remainder of my time for rebuttal.
You very well may.
Thank you.
Ms. Gomez?
May it please the court. I hope you can hear me. I'm Ann Gomez from the North Carolina Office of the Appellate Defender here on behalf of Mr. Hollars. And I've already messed my papers up. Okay, here we go. Excuse me, Your Honors. In 2015, Dr. Bartholomew warned of the need for vigilance if Mr. Hollars' case went to trial because his condition might deteriorate under the stress of trial. Mr. Hollars appeared to decompensate on the first day of prosecuting witness Leslie's testimony. When defense counsel asked Mr. Hollars if he understood what was going on, Mr. Hollars said no, he didn't know what she was talking about. And when he said this, he looked at counsel like he didn't know who he was. The trial court and defense counsel both dropped the ball at this point. The trial court wrote off Mr. Hollars' confusion as confusion over the rules of evidence. And defense counsel initially asked for an inquiry into competence, but then withdrew the request the next morning because Mr. Hollars seemed fine that morning. No one addressed Mr. Hollars' competency the day before. And I'd like to just go and address a few things that the state has argued that some evidence is not enough to be substantial evidence. Well, some evidence is a very vague phrase. And we would argue that some evidence can be substantial evidence depending on what that evidence is. The Drope court, or the U.S. Supreme Court in Drope, said we're not going to set out what the quantum of evidence is. And as opposing counsel pointed out, the court said look at things like irrational behavior, past findings of incompetence, and demeanor. The court also said that even one of those things, depending on what the circumstances are, can be enough to raise a bona fide doubt as to competency. And the some evidence language the state has taken from this court's decision in State versus King, where this court said there is some evidence in the record indicating defendant had received precautionary treatment for depression and suicidal tendencies several months before trial. However, this evidence of past treatment standing alone does not constitute substantial evidence requiring a competency hearing. And so State v. King is really kind of factually inapposite with respect to this case. And very similarly in Badgett, which the state talked about in its argument, the record showed in Badgett the defendant was treated for anger management and depression prior to trial. And this court said this is insufficient to establish a lack of competency. And that kind of evidence really has nothing to do with the evidence in this case, which would include a history of severe mental illnesses and dementia and voluntary and involuntary commitments, with the last involuntary commitment lasting over 5 years before trial. The defendant suffered from schizophrenia and dementia at the time of trial. There was some evidence that his dementia was worsening. There were past findings of incompetency. There had been warnings of decompensation under the stress of trial. And this is the first time that Mr. Hollars had had a trial. So no one would really be able to predict how the stress of trial was going to affect him, someone like him who has such a fragile mental state. And finally,
is part of your argument that the trial court was required to conduct a competency hearing at the very beginning of the trial? just in light of his past history?
I think the trial court should have. And right now in my argument, I'm focusing on this moment where Mr. Hollars appeared to decompensate because at the very least, the trial court needed to be acutely aware of the possibility of decompensation and deterioration of his mental state under the stress of trial. And this appears to possibly be what happened. And the standard is not whether the trial court thinks that the defendant is incompetent. The standard is whether there is substantial evidence that the defendant may be incompetent. And we would contend that given Mr. Hollars' history, it would have been certainly safest to do a competency hearing at the beginning of trial, but at the very least, it had to happen when these sort of warnings of decompensation appeared to come true.
Typically, we rely upon trial judges as fact finders because they're there and we're not. The trial court made the statements that are reflected in the record, interpreting the defendant's expression of not knowing what was going on as relating to the complexity of the evidentiary issue that had been addressed in the immediately preceding part of the trial. What weight should we give the trial court's determination that the defendant's confusion related to the applicability of Rule 404B? And I'll certainly say I've found myself confused about that sometimes, as compared to other things that he could have been confused about. What weight do we give that type of statement by the trial court in our analysis in this case?
Well, the amount of deference that is to be afforded to the trial court's findings of fact or interpretations of the evidence differ depending on whether we're talking about whether the trial court should have held a competency hearing and whether we're talking about whether the trial court erred by finding the defendant competent after holding a competency hearing. So for the latter, the trial court's findings of fact are conclusive on appeal if supported by competent evidence, even if there's conflicting evidence in the record. And it's different when we're talking about whether the trial court should have held a competency hearing. And if the evidence if there can be conflicting interpretations of the evidence, but one of those interpretations is that, or creates a bona fide doubt as to the defendant's competency, the trial court must hold a competency hearing to resolve that conflict. And once the trial court has the hearing, then the trial court gets to decide what that evidence means, or, you know, which doctor the trial court believes. And in
are you contending that the trial court has no right to weigh evidence in determining whether to convene a competency hearing ex mere motu?
Essentially, Your Honor, we're contending that once there is any evidence that rises to the level of creating of being substantial evidence that the defendant may be incompetent, that is the time to have a hearing. And then the trial court, excuse me.
I'm sorry, you go. I interrupted you. Go right ahead.
And then the trial court resolves conflicts in the evidence.
What do you make of the language in King that talks about, well, yeah, you've got this evidence going one way, and then you've got this evidence going the other, and the court's entitled to consider the evidence cutting against a question about incompetence?
I would consider that language unfortunate, and I also don't think it's necessary.
Whether it's unfortunate.
It is unfortunate for me. I do not think that it is correct that the trial court should be weighing the evidence in the way I'm talking about, or that the way we're talking about, well, you know, the look on his face and what he said could mean that he's decompensating, or he just might be confused about the rules of evidence. I think it's just no big deal. I'm going to ignore it. That's what the trial court did here. I don't believe that language in King is really necessary to the holding, because all we were talking about is what was called precautionary treatment for depression and suicidal tendencies, and that several months before trial. And that's it. That was all that was in that record as far as I recall the case. And so that clearly does not raise a bona fide doubt as to competency. If it did, then there would be a bona fide doubt as to the competency of a large proportion of the population. I hope I've answered your question, Your Honor.
Ms. Gomez, in analyzing this issue, are we allowed to look to the fact that, are we allowed to take into account that for the rest of the trial, Mr. Hollars did not seem to have any problems comprehending the proceedings, or alternatively, does our analysis stop at the moment that you're claiming he showed confusion? You understand what I'm asking?
Yes, I do. I think, the way he acted in the rest of the trial is some evidence perhaps that, that is pertinent to the competency issue. However, if he was incompetent for part of Leslie's testimony and then competent for the rest of the trial, then his right to due process was violated. So while the fact that say he had testified at trial and his testimony was lucid, and I believe this was in Badgett that the court took that into account in finding that the defendant had not raised a reasonable doubt or a bona fide doubt as to competency. We really don't have we have no testimony by the defendant. We really don't have any kind of substantive kind of involved colloquies with the trial court. The defendant certainly did not act out at trial. So that has some bearing on this question, but if he was incompetent on January 10th, 2018 for some period of time and could not assist his attorney during Leslie's testimony, then his due process rights were violated.
Well, one of the things that's interesting, at least to me, about this case is the moment at issue, the exchange we're focused on. It seems like it's open to several different interpretations. I mean, I guess one interpretation is he truly did not know what was going on. Another interpretation is that he was confused about the legal jargon with Rule 404B. Another interpretation is when he said, I don't know what she's talking about, he could have been intending to deny the truth of what she was saying. So when we have these multiple interpretations, how does that factor into our analysis?
Well, first of all, with regard to denying the truth, so the state has said in its brief that on page 4, about a third of the way down, that neither the trial court nor Mr. Hollars' lawyer interpreted Ms. Hollars' statement as raising doubts as to his competency. And certainly at least Mr. Hollars' lawyer did, because he asked for an inquiry into competency based on the statement and Mr. Hollars' demeanor. And if he thought that Mr. Hollars is saying Leslie's making this stuff up, he would not have announced this privileged communication in open court. But whether that's a reasonable interpretation or not, given Mr. Hollars' history, given his fragility, given his schizophrenia and dementia, the trial court needed to stop and at the very least make an inquiry of Mr. Hollars. And depending on what that inquiry revealed, possibly sending him for another evaluation.
When did the trial court commit the error that you consider to have been so serious that it was prejudicial? Was it at the beginning of the trial in not conducting a hearing? Was it on the third day of the trial when the proceedings were not stopped at that point, albeit 4:55 in the afternoon, or was it some other time?
I think it's error yes, both at the beginning of trial and certainly though when he has appeared to be decompensating. And it's just that when he appeared to be decompensating, the evidence is just stronger that there should have been a competency hearing.
In terms of the inquiry made the next day by the trial court to defense counsel about the incident the day before, at the end of the day, when defense counsel said, quote, I don't have any concerns this morning, unquote, Does that make a difference at all in terms of what the trial court did from that point on? Or was the error so egregious at that stage that no matter what defense counsel said the following morning, error had set in?
Well, I'm interpreting what defense counsel said the following morning, and I don't have the exact transcript in front of me, but that he said, I had some concerns last night because he looked at me like he didn't know who I was. I don't have any concerns this morning. And I'm interpreting that to mean he's fine this morning. And the court just kind of said, okay, let's go. And nobody talked about, the court didn't ask defense counsel, do you mean that you think he was fine yesterday based on, whatever you talked about or something? At best, it's very unclear.
So you're saying that the trial court at that stage was continuing the error from the day before in not going further with defense counsel, as opposed to just taking defense counsel's word that there were no concerns that morning?
Well, even if there were no concerns that morning, nobody addressed the concerns that arose the day before. And so if there were no concerns that morning, okay, fine, there were no concerns that morning, but there needed to be some kind of inquiry into what was going on with Mr. Hollars the day before.
Was that on the trial court then to sua sponte, do that on the trial court's own volition?
Yes. Under certainly Pate v. Robinson and Droke v. Missouri, the trial court has a constitutional duty to sua sponte, institute a competency hearing whenever there is a bona fide doubt as to the defendant's competency. So it's not on defense counsel to do this. The trial court's supposed to do it.
I have a quick question, I think, backing up a little bit. The state argues that, as in State versus Young, where there was a determination of competency sometime before, that there's a presumption sort of ongoing competency that's entitled to some degree of deference, if I understand the argument correctly. How, if at all, does that case affect this one, and at what point would that change?
I didn't read Young as creating some sort of presumption. And what Young says is, whereas here the defendant has been committed and examined relevant to his capacity to proceed, and in that case, the defendant was evaluated once and found competent. And all the evidence before the court indicates that he has that capacity. He is not denied due process by the failure of the trial court to hold a hearing, blah, blah, blah. And so I just see that as really setting out a totality of the circumstances test that the court should examine all the evidence before the court. And we don't disagree with that statement. It's just that we disagree with the state as to whether all the evidence before the court indicated that Mr. Hollars might be incompetent.
Okay.
I have another question for you. I don't think our case law has ever really fleshed out what a competency hearing has to involve. In your mind, what are the minimum steps that must be taken for it to truly be a constitutionally sufficient competency hearing?
That's a great question. And as I said earlier, at the very least, I think, as defense counsel has suggested, the trial court should have questioned Mr. Hollars. And depending on what that questioning revealed, that might have sort of been more evidence that he was not doing well and that he needed to be evaluated. I think, again, that's going to be such a fact-intensive thing that there's not going to be any kind of bright line rule as to what it needs to involve. But
so it doesn't necessarily need to involve a medical expert coming in and giving testimony, reviewing records, etc.
No, I mean, for instance, if the trial court had done a short inquiry of Mr. Hollars and said, Mr. Hollars, you just had told your attorney you don't understand what she's talking about. What did you mean? And he said, oh, you guys were talking about a bunch of statutes and stuff like that, and I was getting really confused. I don't understand statutes. Okay, Mr. Hollars, do you understand what Leslie is saying when she's testifying. Oh yeah, I understand that. I mean, that may have been adequate.
Okay.
And in Drope versus Missouri, the court said even when a defendant is competent at the commencement of his trial, a trial court must always be alert to circumstances suggesting a change that would render the accused unable to meet the standards of competence to stand trial. And given Mr. Hollars' history, the trial court should have been acutely alert to anything indicating Mr. Hollars may be incompetent, and that did not happen here. Our statutes provide a hearing procedure for competency, and the protection afforded to a defendant by this legislation is illusory if, when a bona fide doubt as to his competency arises, neither the trial court nor counsel seeks to utilize the procedures provided for determining competency. And that is a little summary of a sentence from Meeks v. Smith from the Western District of North Carolina. And in summary, with respect to the direct appeal, everybody dropped the ball with respect to Mr. Hollars' competency. Nobody bothered to jealously guard Mr. Hollars' right not to be tried while incompetent. I'd like to quickly turn to the MAR for a few minutes. The state has taken no position on the merits of the MAR and asked this court to dismiss the MAR only to have Mr. Hollars, who suffers from schizophrenia and dementia, file a pro se MAR in Superior Court. Mr. Hollars is only entitled to appointed counsel for a Superior Court MAR if an evidentiary hearing is ordered. He is not entitled to appointed counsel to file an MAR for him in Superior Court. If this court believes that the allegations in the MAR, if resolved in Mr. Hollars' favor, would entitle him to relief, then the only purpose to be served by dismissing the MAR rather than remanding it to the trial division for an evidentiary hearing would be to deny Mr. Hollars access to justice and to the courts. And in my memorandum of additional authorities, I attached 2 orders in which this court remanded cases based on MARs on appeal.
Well, since the Court of Appeals majority did not address the MAR, wouldn't one option be for us to remand it to them to decide what should be done?
I had not thought of that, Your Honor, but that would be another option. And we believe that Mr. Hollars is at least entitled to an evidentiary hearing based on the MAR. Dr. Bullard's 2017 report finding Mr. Hollars incompetent a little over 6 weeks before Dr. Bartholomew and Dr. Utterback found him stable for the past year and competent to proceed severely undermines the state's arguments on direct appeal and the reasoning of the dissent, specifically that Mr. Hollars' competency was directly correlated with his dosage of medication and that he was always competent when he was taking 10 milligrams of antipsychotic medication. And also that Mr. Hollars was only found competent in 2012 and 2015 and was always found competent between 2015 and 2018. So not only was Mr. Hollars found incompetent in 2012 and 2015, he was found incompetent in 2017 when he was taking 10 milligrams of antipsychotic medication. And in his 2017 report, Dr. Bullard said, even though Mr. Hollars was taking his medication regularly, he had active psychotic symptoms. Therefore, the linear progression posited by the state of Mr. Hollars getting better and better through treatment and medication at Broughton is an illusion. And I would also like the court to bear in mind that Mr. Hollars was suffering from dementia. This was untreated. It may have been getting worse, and it was not going to get any better. Therefore, if this court is not inclined to rule in Mr. Hollars' favor with respect to the direct appeal, we'd ask this court to consider the MAR and at least remand for an evidentiary hearing, or what, as was suggested by Justice Davis, to remand the MIR back to the Court of Appeals. And in conclusion, the trial court's failure to jealously guard Mr. Hollars' right not to be tried while incompetent violated Mr. Hollars' right to due process. Alternately, defense counsel's failure to jealously guard Mr. Hollars' rights amounted to ineffective assistance of counsel. If there are no further questions, we would ask this court to affirm the Court of Appeals majority or alternately grant Mr. Hollars release based on the MAR. And if there are no other questions, that would be my argument. Thank you for listening, Your Honors.
Thank you, Ms. Gomez. Mr. Broad.
Thank you, Madam Chief Justice. I have two main points that I want to make. The first point goes to the motion for appropriate relief. I think it's really important to draw a bright, bold line between the issues at play in the motion for appropriate relief and the issues at play in the state's dissent-based appeal in this case. The state's dissent-based appeal in this case is raising a 14th Amendment question that asks whether a reasonable trial judge would have had a bona fide doubt about Mr. Hollars' competency. And the trial judge can only rely on the evidence before the trial judge. So in the motion for appropriate relief, there's discussion of this 8th report. The 8th report, I think everyone agrees, was not at any point before the trial judge. So I don't think you can fault the trial judge for failing to consider or analyze this 8th report that everyone concedes was not before him. So I recognize that the MAR is raising a distinct set of issues from the state's dissent-based appeal in this case. As we said in our response to the motion for appropriate relief, there are numerous fact issues that are raised by the motion that can't be adjudicated by this court in the first instance. No court has passed on any of this evidence. Our position is that dismissal without prejudice is appropriate, but I recognize that you could choose to remand this either to the Superior Court or, as Justice Davis mentioned, to the Court of Appeals. My second point goes to a question that Justice Davis asked, and I think really is the heart of this case, which is, what do you do when you have a record that's ambiguous, when you have a record that's subject to different interpretations? I think there's at least 4 different ways of reading the record that we've discussed this afternoon. The first way is to read it like the trial judge read it, which is to say that Mr. Hollars' confusion at this midpoint in the trial owes to the parties' discussion about this technical rule of evidence that he didn't understand. I think that's one way of reading it. The second way of reading it is how the dissent below read it, which is this statement sort of denying knowledge is essentially Mr. Hollars' way of denying responsibility for the crimes. The third way of reading it, I think, is something along the lines of what defense counsel represented to the trial court that afternoon, which is this was a concern, but maybe an unclear concern about, sort of what was going on. And then I think the fourth way of reading it is the way that Mr. Hollars has read it on appeal, which is this is evidence that Mr. Hollars could not understand the proceedings and could not reasonably assist his attorney. This trial happened more than 2 years ago. None of us were there. We don't have the benefit of a live stream or being able to watch it on YouTube. I don't think there's any way that we can sort of conclusively decide what happened. And so I think this case raises the question of, well, what's the legal rule? What's the rule that's going to help decide what to do when a record like this raises kind of this ambiguous question about what was going on and whether the defendant was competent? And I think the legal rule comes from this court's decision in State against Young, Justice Hudson, which you mentioned, which I read to set something like a presumption. I acknowledge Young doesn't use the word presumption, but I think it's a fair reading of Young, that Young establishes a presumption that once you reach that critical moment in the record where all of the evidence before the court shows that the defendant is competent, there is a presumption that no further hearing is needed unless and until substantial evidence raises a bona fide doubt to kind of change that presumption. And for the reasons
just a quick question about that. In Young itself, there wasn't a determination prior, was there, that the defendant was incompetent?
Your Honor, I agree with that. I'm getting my reading
Is
of Young.
that significant in your interpretation of the case and its applicability here?
Your Honor, I don't think it's significant to my reading of Young because I'm drawing from the language in Young that says when all the evidence before the trial court indicates that a defendant is competent to proceed, and I'm paraphrasing here, he's not denied due process by the court's failure to hold another hearing. I think that's the language that creates the presumption in Young, and I think the Young presumption is conclusive here and why the decision below should be reversed. And with that, Madam Chief Justice, I'll yield my remaining time.
Thank you, Mr. Broad, Ms. Gomez, and Mr. Green. Madam Clerk. Madam Clerk. You may be muted.
I was sorry, Chief.
Okay.
Oh yes, oh yes, oh yes. The Supreme Court of North Carolina is now in recess. God save the state and this honorable court.